Oh, are you talking about the broadcast? We're about to start in
Hi,
any minute.
Catherine. Hi, Catherine.
Did you get the link?
Okay. Hi, everyone.
Yes.
Hold on just a
Okay.
second. Okay, so welcome to WLJA, Common Law Under God. And I am Luciana, and I'm here with Catherine Hine. Hi, Catherine.
Hi, Luciana.
Sorry, you were on the phone.
Yeah, someone had called in to thinking that's the way that they got on the broadcast, but
okay.
you just click on the link, and that's
Right.
how you get on.
Right.
And you can contribute either by going on the live stream chat box, or you can just start talking.
Mm-hmm. Yeah, we'll pull you in.
We're not muting anybody's microphone at this point.
Right.
So,
right.
Okay. All right. Well, as you know, the title of the broadcast is Explaining How the Bar Association is a Criminal Enterprise. And we don't undertake that accusation lightly, and I'm confident that we have proved that about 7 ways to Sunday. And we're going to explain to you how. First, as I try to do on each broadcast, I want to open with a prayer. And I've got it written out first because I'm not too good on the fly sometimes. Lord, forgive us for our idolatry. Help us recognize that we have made an idol of the bar, its human members, and its so-called rule of law, created as a perversion of the sacred law you, Heavenly Father, gave us so long ago through Moses. Forgive us because out of our further sins of greed and having turned our backs on you, we have been worshiping these idols by rising when the black-robed priests of hell enter the room. Instead of worshiping you, we have been worshiping them by quote unquote pleading and quote unquote praying to them through our spoken and written words that we utter ourselves, or by means of the evil intercessors we hire to do such groveling on our behalf. Forgive us for perpetually deferring to the bar and its evil handmaiden, the bench. Forgive us for refusing to recognize that these bar associations are designed by means of corporate artifice to harm others without liability to its members. Give us the strength, wisdom, and courage, dear Lord, to drive these people out of our lives and bring them to your justice as best we are able by learning and applying your word in our daily lives. Amen.
Amen. Thank you, Catherine.
I want to at least correct the any ignorance we have. My scripture tells us, my people perish for lack of knowledge. I don't want anybody to lack knowledge and perish for that reason. Because, I don't think perish is too drastic a word for what we're facing and what we have been facing the last 2 years and through the multiple wars before that. So we're just knowledge alone is not going to be enough. We're going to have to use that knowledge, apply that knowledge, and take action, as we are doing with the Ohio Circuit Court of Record. And anybody can do that yourselves, and I will help you. You can start forming your common law courts that and grand juries that will start bringing these people to account. But in the meantime, I think some of you may need hard and fast evidence that we indeed do have that right. We really aren't slaves. So, addressing that, I would, I want to get into the title of nobility amendment. And this seems to be a sore spot for them, and it doesn't need to be for us. We've got the high ground on this one. It's not the only reason that the bar, and referring to the bar as people who are considered attorneys and have sworn allegiance to corporate bar associations or the constitutions of, we thought it was the constitutions of our state republics and our national republic, if we ever had one. But indeed, it was, they were swearing allegiance to who knows what, corporate charters.
Yeah.
And I'm not sure just what I swore allegiance to when I was a member I got sworn in 1977. But it was done orally, and so I don't have any record of that.
And you were an attorney for 40 years in the state of Ohio.
Yeah.
It's a long
Right.
time. It's a long time.
42 plus, actually. Yeah.
Oh, wow. Okay.
So anyway, one of and a lot of what I'm telling you all tonight is not something that I knew during those 42 years. It's something I have learned since then. And I'll just get into first what this broadcast is really focused on, and that is the title of nobility amendment, the original 13th Amendment to the 1787 Constitution. And that's the one that the bar and the politicians and everybody want you to forget about. But they have done everything they can to eradicate all traces of it. But they've not been entirely successful. I was found as an attorney dealing with liars, especially liars on the witness stand, that it's difficult to maintain a lie consistently over time. And they're not going to be able to do it either. I hope it matters. I hope it matters to those of you who are listening. Are you going to be able to post that that exhibit that you created for us, Luciana, that's got the language of the original 13th and along with the image?
Let's see here.
I can start reading it.
Yeah, I have the titles of nobility amendment.
Yes, that's it.
Hold on. Okay, I'm going to pull that up right now. Hold on one second. Okay.
All right.
Okay. Tell me if you can you see it?
Yes. Okay. And I'm not sure how well people okay, that's better. Okay. Can we scroll down to where we can read it? I assume the type is a little bit smaller. Wait, that's the article. No, this would be, and we're going to deal with that in a minute. But no, I'm talking about the image that you created with the title of Nobility Amendment spelled out underneath it.
Yeah, I know. I just walked in like 5 minutes. I could pull it up in just a few minutes.
Okay, I'm going to start reading it, so take your time. If any citizen of the United States shall accept, claim, receive, or retain any title of nobility or honor, or shall, without the consent of Congress, accept and retain any present, as in a gift, present, pension, office, or emolument, which is an honor, of any kind, whatever, from any emperor, king, prince, or foreign power, Such person shall cease to be a citizen of the United States and shall be incapable of holding any office of trust or profit under them or either of them. Remember, this was written in 1810, and their word usage is a little bit different than ours, than they perverted it into in subsequent statutes and codes. So, and you can see the way the amendment is written. It's got the British spelling of honor. Because these people, hadn't been that long that they were British citizens, or I should say subjects. Right. So, well, who does that apply to is the question. And everybody knew who it applied to at the time it was written, and everybody knows who it applies to now. And it applies to their emolument of the title Esquire. And that's a title that is just beneath, it's a British title, just beneath the designation of Knight, Knight. So if you're able to find that, we can show a depiction of what an esquire looked like, and with the title of nobility amendment printed out.
Okay.
Underneath them.
Okay, can you see it now?
Yes. Okay, yeah. The man with the stick over the peasants is the esquire. Okay, and this is, like the title of knight. It's an old, medieval concept, but a feudal concept, and our current enemy kind of likes feudalism, and you see a lot of traces of it in our the way we hold title to property. And if you own jointly with somebody, it's called a tenancy in common. And anyway, they don't use the term vassals so much, but there's certainly a desire on their part to return to some sort of neo-feudalism. And they also like, a dab of Roman civil law.
I was going to ask you in that picture, what is it that they look like they're gathering up something there?
I think they're harvesting some sort of grain, looks like.
Okay.
And he's making sure that they stay bent over doing it, Okay. So we've been seeing, and actually we saw even in Ohio, there's been in some of their disciplinary proceedings against themselves, against some of their members, that they will divest someone, and this happened recently in Ohio, of their right to use the term esquire. I never used it myself, but other people do, and I guess they're entitled to do that, and it's certainly a foreign emolument. But it's not just the title; it's the fact that the members of the bar are following rules that were set out by foreign corporations, including the American Bar Association, which is a subsidiary of the International Bar Association. They're both corporations, and corporations are always foreign to the people. And they have their own rules for their members, but they also impose rules as to the conduct of what they're still I don't know if they call them the people's courts anymore, because they're not the people's courts. They're the courts of their corporate tribunals. And in their corporate tribunals, those are being run by their rules of civil procedure. Every state of Ohio, state of Indiana, state of Washington, they're all governed by rules that were created by the bar associations. The organized bar, usually the ones at the top, and this is international. So they might tweak them a little bit for use in different countries, but the Anglo-American establishment, the bar associations of the various Anglo-American establishment countries derive their, very similar rules from the International Bar Association.
And Oksana is asking, she says, the other question, are they so-called citizens? Are they so-called citizens?
Oh, I'm sure they still call themselves citizens. In fact, they are. I mean, they're certainly enslaved people. I won't tell you that. They're enslaved, but they're acting as legal fiction persons when we run into them. And I'm not clear. Let's see, what's the question there? Are they still citizens? Yeah, I'm sure they consider themselves that.
So-called citizens. She said, what about honorable? What about honorable?
Honorable is another title that they like to take on. And, the worse they are, right, the more honorable titles they heap on themselves. As far as really being a citizen of United States is a corporation. It's a conglomerate of corporations. So to say that anybody, even they, are citizens of United States, the corporation or one of them, or it's like saying, you're not a citizen of Walmart or McDonald's. They're corporations too. You can't be the citizen of a corporation. You might be a shareholder, and you might be an agent. You might be an employee of a corporation, but you're not a citizen of it. Corporations are not nations, but they masquerade as nations. And state of Ohio, for example, masquerades as a state, as a political subdivision of United States. The corporation masquerading as a country. And even the entity known as Government of the United States of America, I think located at Pennsylvania Avenue, same address as the White House, it's still a corporation. It doesn't become not a corporation. There is no country. Well, however you choose to name it. Okay, yeah, there's some questions about how much traffic we get through our episodes. However, I really question how honest that assessment is. And I would also warn you that certainly the last few times that I have attempted to comment on our own broadcast, my comments are never visible. Curiously, YouTube will show like 2 comments if I make 2 comments, or if I make one and there's already another one, but you can't see them. I've even asked someone else, will you please post this? And they have tried, and they're not allowed to comment. So,
Hi, Mike. Hi, Mike. Hi, Angie.
Hi, Mike. Hi, Angie.
How are you guys doing? Oh, we lost Mike. Mike said that his battery was almost dead.
Yeah. Well, if you want to say anything, probably you better do it quick. Want to contribute something, Mike?
Oh, I think he's already died. Yeah.
Okay. Angie, did you want to add anything?
No, not yet.
Okay.
I think he said he's down to 13%.
Oh, there he is. Hey, Mike, how are you?
How are you?
I'm good. Keith just added that the bar, for the most part, only takes care of the corporate court and what they're told, and really do not represent individuals, but the corporation at large. It's an illusion that you will be represented by them, and it's only the perception of, and profits are their bottom line, just like any corporation, right, Catherine?
Yeah.
That's
just another word usage. They think that they've co-opted the term individual also. That individual is another one of their legal fiction persons. So, to some degree, when we do our documents, we stay away from the words they think they own. But we're not required to do that. We don't have to do that at all.
right.
So they think they've co-opted the term individual, and the term one word that a couple of words they have not taken ownership of in their statutes and codes are the terms man and woman. They seem to know to stay off of God's turf. They didn't create men and women, and they don't legislate or purport to legislate about them. However, if they can get you to agree to act as a legal fiction person, then they seem, in their little fantasy world, apparently they seem to think that they can operate that way.
Yeah, Keith said they only represent the all caps name.
Right. Yeah. But when you hire an attorney, the attorney represents your all capital name, and yeah. So and a person, I don't know, we got into that, the definitions they have of human beings. If you say you're a human being, you're presumed to be an infant of the species Homo sapiens. So you're really kind of an infant animal, too. And that's really how they look upon us. But bar members do more than just, represent people in court. They set policy, they set rules, they populate the legislatures. Not that the legislatures are capable of enacting law, but a lot of people believe falsely they do. So it's a scam, and they've been running it a long time.
Right.
And,
right. A very long time. That's why, I hear so many people say that they don't want to fight them. They're too big. They've been around too long. You can't beat them.
Well, it's like any battle. You don't go where the enemy is strong and knowledgeable, and you are weak and ignorant.
Right.
You take them on where you are strong and knowledgeable, and they are ignorant and weak.
Right.
To engage in any kind of particularly life and death struggle without giving yourself every advantage is foolish. And to play on the enemy's turf is insane. And this is how I'm trying to explain to you how it's insane and how they are not the all powerful ones that they claim to be. Their fake power is resting on lies, in a structure, like a house of cards. Their violation of the Titles of Nobility Amendment is just one of their violations, but it's one that they seem to be concerned about because they argue about it a lot. And maybe this would be a time they argue that it wasn't ratified by the correct number of states at the time. So now might be the time to bring up the Brian March study that was done in the late 90s and has a lot of original documents and, back from the 1800s, as well as affidavits from Library of Congress people confirming the ratification. So if we can get that posted, what you had up earlier, Luciana?
Oh, okay, sure.
Okay. And they still want to argue about this, but I don't think there's really anything more to argue in light of this study. He covered really everything you could imagine to cover. He worked with, he's a man out of New Mexico, and he worked with a couple of other people.
Oh, Brian March. Okay.
Yeah. Okay. So he, let's see. There's a lot of moving parts.
Can you see it on the? Yeah.
Yeah, we can
see
scroll
it on the screen?
through it.
Okay.
Yeah, if you at the beginning, he at the beginning he thanks the people who helped him with the study, and it was a major operation because he knew that even then the organized bar was fighting him tooth and nail because they did not want to see this happen. There's every bit of evidence to suggest that the War of 1812 was in good measure an effort to eradicate all evidence that the Titles of Nobility Amendment had in fact been ratified. It was ratified, I believe this proves that it was ratified as of March the 12th, 1819. After that, a bunch of other states also ratified it. But
I in his dedication, I like how he ends it by saying, and finally to the American people who will have the intestinal fortitude to take these truths and use them to restore the Republican form of government that was given us just 219 years ago.
Yes. Amen.
That's a great way to end the dedication. I love that.
Yeah. And he organizes his information with, he tells you what the amendment said, and then he's got affidavits that authenticate the documents that he attaches. And these were coming from, librarians from the Library of Congress. So,
Wow.
I don't know how they're going to dispute that. In fact, they know they can't dispute that. I'll remind people every time we do a 3-notice process and tell them they have no authority because they're precluded from operating in positions of public trust by the Title of Nobility Amendment. They never dispute us. We give them 4 chances to dispute it, and they never do.
Right.
Okay, so going to page 4, I like the part where he said at the final paragraph, if you did want to change the course of history, contrary to a lawful enactment, what would be the means by which you could accomplish that task? That's that's how he embarked on his investigation of what exactly did happen. And he said you could wait until the players of the enactment died, or destroy or burn any records of its existence, and pretend it doesn't exist for a few generations until it is gone and forgotten. All of these methods were employed to try and erase the ratification of the Titles of Nobility Amendment. We have much more documentation that is not addressed here, which will be addressed in subsequent works. The means by which the demise of the Title of Nobility Amendment, supposedly, was almost accomplished will be addressed in much greater detail later. I don't know if he ever got an opportunity or lived to have an opportunity to do that or not. But
Well,
this is plenty.
I'm going to be looking for that. I didn't dive into this as deeply as I could have. I've been so busy, but I'm definitely going to find it if it's out there. You know me, Catherine.
Oh,
If
yeah.
it's out there, I will find it.
Okay. And if you scroll down to page 6, you see Article 13 again, as we read it. That was actually part of the Constitution. This, remember, the current Article 13, so-called, the one that Lincoln put out there, that didn't happen until, half a century later, after this was all ratified. So that's the one they try and cram down your throat. That's the one about involuntary servitude, and they've got a gotcha in there, but voluntary servitude's fine, and if we imprison you for one of our offenses, that's fine too. So they thought they would eradicate the original 13th by enacting over it, but they never repealed this one. There is no, and trust me, if there had been any evidence they repealed the original 13th, we'd be seeing it. It isn't there. And this document establishes that. There's no question at all. Even the Black Robe Demons admit that that 12 states ratified within from between about 1810 and 1811. Ohio was one of them in January of 1811. At that time, in order to amend, there had to be 13 states. So the question is, where was the 13th state enactment? Well, I believe there are a number of states, but they're saying the state that actually put the Title of Nobility Amendment over the top was the Commonwealth of Virginia. So they ratified it without question on March the 12th, 1819. So that really, and that's in their official documents all over the place, that Virginia was the 13th required state to do the ratification. And so wouldn't you know, let's just look at that, the proof that there is of that. You scroll down to page 9 and then on to page, I think the next one is 15 that I wanted to call people's attention to. This is the request by CEO James Monroe. I guess at that point, I don't know if the United States was a corporation at that point or not, but President, CEO, whatever, James Monroe requested that that there be an answer to the question, because they were starting to get worried in 1818. Okay, they'd already had the War of 1812, and Washington had been burned to the ground, and a lot of courthouses had been burned to try and get rid of this amendment, because a lot of their big deals were bar members.
Mm-hmm.
So
is this on the right page, Catherine? It starts the President of the United States. Because that's page 15.
If it's computer page 15, the Secretary of State to President of the United States,
Right.
that's
Okay.
part of his letter, yeah. And then you see at the bottom, it's got James Monroe, and then a signature. Wait, no. Scroll back up. Back up. It doesn't show your pages. Computer page 15.
Oh, is this
Okay,
it
that's
here?
it. That's it. That's
Okay.
to the House of Representatives. That's James Monroe, his letter of February 4th, 1818. And he acts as if he's making an objective inquiry, but of course I don't think he probably was. And then the subsequent pages show you how, if you get to page 20, you start to see the documents from the Commonwealth of Virginia where they enacted the Constitution with the 13th Amendment, the Entitled Nobility Amendment included in it. So if you go to computer page 20, you're going to see.
Is this it here? From September 30th?
That's a documentation from the Library of Congress that these documents are genuine. And I think they're in making the copies. She's confirming, or he is confirming it by what the page, the top of the page stated, and so forth. And I think there's Scroll down. Let's see. Is it sworn? Yeah, I think it is.
No, I don't think so.
Maybe not. Okay.
No.
All right. So now, in the next page, you got from the acts of the General Assembly of the Commonwealth of Virginia, and this is. Now, you're not going to find this stuff in current statutes because they've scrubbed them. Okay?
You're not going to find it on Google. It's not going to be on Google, probably. Maybe in the dark web or whatever that's called.
Well, we've got it. And we've got it through the work of these researchers. Isn't that interesting? That there's some kind of a reference to University of Toledo Law Library. That's where I went to law school. Anyway, so let's keep scrolling, and then I think it's at page 26.
Okay. Here? This is computer page 26.
Is that? Yeah, does that show Virginia published on March 12th, 2019? Let me switch screens again.
It's kind of hard to.
Kind
of hard to read.
It doesn't say what computer page
this one?
is.
The one we're looking at now is computer page 25, Catherine. This one is 25.
All right.
The revised code of the laws of Virginia.
Okay, so scroll one more. Okay, I think if you turn your head to the side, you can kind of see the see where it's included in there. It's on the. Keep scrolling.
Is this the one though?
No, I can't tell which computer page you're on.
28. 28, Catherine.
All right, there it is. You see it? Where the arrow is on the left?
Which part of it?
On the left.
Okay. Let me see if I could zoom in there.
It's right in about
Yeah.
the middle of the page. There it is.
Yeah. Scroll down. If any citizen, see where it is? Scroll down. Yeah,
Yep.
there it is.
Oh, I see
There it
it.
is.
Yeah.
Last paragraph.
Okay. So that's from
Yeah.
the Virginia official records of what the United States Constitution of the day looked like. So they have it in there. They must have ratified it. And nobody's saying they didn't ratify it now. They tried to at first, but now they got to find some other excuse. So, and they have, I don't know, this is kind of dry material, but I just want people to know that it's available. We've got it in our hard drive. And there were many other states after Virginia and the first 12. They tried to say, oh, well, it took more than 13. Well, anyway, Brian March explains how, because there were other states that were admitted to the Union between 1810, when the amendment was introduced, and 1819, when they got the 13. So they say, oh no, then it wasn't 3, the number that needed to ratify wasn't 13 anymore. And, but there have been other states that have ratified since, many other states. And if you go really fast through the rest of the document, you can see where many other states, including, let's see, I don't know, Colorado, Indiana.
There's a lot in here, Catherine.
Yeah.
It's actually 157 pages.
157 pages, yeah. And that's from their statute books, from the states, showing that, for decades after the amendment was introduced, states were including that in their official versions of the United States Constitution, which was, posted in their so-called laws. So they always considered it to be a valid enactment.
So they went ahead and buried this thing out of sight, out of mind, so everyone would just forget about it or not know about it.
That's what they did. Okay. I don't know. We've probably done this to death. I don't know if people are, tired of looking at that, but I can't overemphasize, I think, how important it was and how much mistrust early Americans had of any title of nobility, and they hadn't yet discovered the full horrors of bar membership, but they knew that they didn't want people with their boots on their neck that had that were taking their orders from a foreign power.
Right.
So, okay. There have been some question too about whether state of Connecticut redacted it, and they did. Not redacted it, but whether they ratified it, and they did in 1821. There was some delay about it, finding it, but whenever you've got statutes published by the authority of the state, that's considered to be all you need. Okay, but that's not all that we have as far as why bar members. Well, before I get into all that, why is it important that these people never had authority? They didn't have authority today. They didn't have any authority ever since March the 12th, 1819. So what have they done with their lack of authority? What does that mean for the legislation that they created, for the so-called treaties that they entered into, including the current one, or the one they entered into in the 1940s to get us into the United Nations? I mean, they got state of, the various conglomerates that comprised United States, the corporation. They got it into the corporate United Nations.
Yeah.
In 1947, I believe it was. And they take it upon themselves to decide, what kind of wars we're going to have in the future, and who's going, what kind of a vote that the other corporate so-called nations are going to have, and will it be at one time, the United Nations had to do things by unanimous vote, and now they sort of changed their mind, and 2/3 should be good enough. And anyway, but nobody asked the question, who are these people? What are they doing? Who gave them authority to tell us when we're going to be at war with some other people? If they had no authority at all, that's a very big deal. And it's a very big deal for the people of the world. It means that their treaties, and they made sure, their treaties that we never get to really look at before they sign them. Their treaties have the same effect as the Constitution itself, but yet they don't have to go through the formalities of amending the Constitution, so they do it by treaty. Yeah, clever. Now, there's also the Foreign Agent Registration Act, which I think has gotten in the news somewhat in the last little bit.
Of the same document, Catherine?
No, that's different.
Where's that? Which one are we looking at?
No, I'm just going to talk about it. I don't think we have the Foreign Agent Registration Act enacted.
Okay.
I mean, we don't have it on something we can post up there, but I'm going to talk about, I'll give the citation out in a bit.
Right.
Okay. But I wanted to just mention, some current events and maybe a possible explanation for those who think that the bar is not that big of a deal and they don't have that much power. If you take a look at recent events, I think Keith was telling me about this, about, we've all seen the recent plea deals entered into by Trump attorneys Jenna Ellis, Sidney Powell, and Kenneth Chesebro, and facing the same kinds of plea deal threats are attorneys Rudy Giuliani and John Eastman. And my question is, these are very what they're accused of are basically very complex statutes, and that were enacted by fellow bar members. And there's some serious questions about whether these people certainly had any criminal intent. I don't know. It seems kind of odd. I mean, the whole thing, I think, to most people think, it seems very odd about, an election that pretty clearly should have gone one way, and now the one who apparently stole the election is now playing the victim. So I don't know. The whole thing stinks, and I would have thought that these bar members would have, instead of pleading guilty and facing, sanctions against their bar card, would have fought it. I would have thought, I mean, didn't they kind of build themselves? We're fighters, we fight for what's right. They won't even fight for themselves. Why is that? What do they know the rest of us don't know? Could it be that they know that they had zero chance, even with the facts and the law on their side? They had zero chance of beating whatever they were being accused of by their fellows in the organized corporate bar. And that because they know that when they gun for you, you're supposed to just give up. And that's what they've done.
Yeah. Are you looking for the amendment of the United States Foreign Agents Registration Act?
No, I don't. I didn't know the Foreign Agent Registration Act had been amended. Are you saying it has? I don't know that.
I'm seeing something under Public Law 89-486, 89th Congress from 1966 to amend the Foreign Agents Registration Act of 1938.
The form it's in now is, I'll give you the citation. Okay, it is 22 United States Code, section 611, C1. And I got this about 2 years ago. Who knows what's happened to it since? But I assume that it's still requiring those who are engaged in or who are acting at the order, request, or under the major direction, control, or supervision of a foreign principal, like International Bar Association, for example. That's a violation of their 22 U.S. Code, Section 611, C1.
Can you see it there on the screen, Catherine?
Let me look at it. C1, let's see. I have to blow the screen up. Let's see. That should be it. Foreign principle. Yeah, all right.
C1.
Okay. Any person, and that means a corporation, of course, or any kind of legal fiction who acts as agent. All right. So that could be the International Bar Association. Or no, it could be a bar member who, who agrees to act as a person at the order, request, or under the direction and control of a foreign principal, and that would be like the International Bar Association. Yep. Among other foreign entities that they act on behalf of. That's just the one we know about that they all act on behalf of. And if they engage in political activities, then, I mean, isn't almost everything a political activity? Kind of vague. But whenever we accuse them of it, they never deny it. They are, they certainly solicit and collect. Okay, scroll back up a little bit. For I'm looking at subparagraph 3. Further down.
Oh, sorry.
Further down.
Okay.
No.
Oh, went too far. Sorry about that. It's up where right here, right?
Yes. C, subparagraph 3. I. Subparagraph. Scroll up. Oh, no, down. Okay.
Right there.
Okay. Yeah. Okay. And then the next one. Stop. Okay. Stop. Contributions. Okay. Well, yeah. Aren't they? And all of them, aren't they paying bar dues that go to the International Bar Association? Aren't they? Every time they file documents in their fake tribunals, that's going through the CRIS system, the Court Registry Investment System, through a series of transactions into the Federal Reserve Bank. And then from there to a Rothschild-controlled bank overseas. So
we're gonna have to do a show just on Chris, Catherine, soon.
Just on what?
On the CRIS system, the Court Registry Investment System.
Yeah, there's. I'm not real great at surgically examining their operations, because I really want to focus more on the solutions. We can go, because their crime schemes are complex, and they're meant to be very difficult to decipher. I just want to uncover enough of them so that you can see, the rabbit hole that you'd have to go down to see. And sometimes the rabbit hole isn't that deep, and you can see, for example, with FARA, that what they're doing is in violation of the Foreign Agent Registration Act, just by virtue of the civil rules that they're following, that are created by a foreign entity, being the American Bar Association. Every corporation is a foreign entity to living people. Okay. So, yeah, I just wanted to, I promised somebody I would bring this up, and because it's another example of the enemy's tactics, and that is to erase history. And we see that with the monuments that were in some of the southern states, that the people there are pretty upset about, because and there's no question, of course, slavery was a horrible thing, but the Civil War was not fought about slavery. It was fought about taxation. And Lincoln repeatedly said that he wasn't concerned about slavery. It was going on in the North also. He just wanted to, to collect these taxes from the cotton trade. But you would think, if your concern was to just look at, to preserve the history of what happened as a result of that cotton trade and the slavery and the bloodshed of the mass murder we call the American Civil War, tearing down the statues that commemorate that would not be something you'd want to do. I think what you might want to do is erect another statue, for example, to Harriet Tubman, who led a lot of slaves through Ohio, as a matter of fact,
right.
Out of slavery. So let's do that. Let's build instead of tear down, but no, not with these people.
Hmm.
And
you had mentioned talking about the Clayton Act and the Sherman Act, right?
yeah,
With the monopolization that the Bar Association is involved in.
Yeah, bar members participate in and financially benefit from all kinds of contracts and other acts that create and maintain commercial activity within a system of corporate enactments designed to deceive the people into a widespread and false belief that those enactments are law. Okay? They're also deceiving the people that the only source of justice will come through the council and the enactments and the edicts of bar members, when there was a perfectly okay functioning justice system in the people's common law courts early on in the struggle against King George. Okay, in Section 1 and 2 of the bar's own Sherman Antitrust Act, known as 15 United States Code, Chapter 1, that's the section that defines monopolistic activities. And this isn't just my imagining that, the bar is involved in anti-competitive activities. Back in 1975, with the decision in Goldfarb versus Virginia, 429 United States Code 773, there was price fixing, obvious price fixing that concerned a couple who was trying to get a quote for someone, an attorney, to handle a real estate issue with them. And they were getting the same quote from a whole bunch of bar members until they went to one bar member who quoted something significantly lower, and came to find out that that there was a bar rule that any bar member charging less than X amount would be considered to be engaged in malpractice or something like that, would be disciplined, bad things would happen to them. And so, in fact, what was happening is price fixing. And price fixing, where you've got competitors that don't act like competitors anymore. They agree, we're all going to charge the same thing for this. And there are no opportunities for the consumer to get a different price. Maybe there's other factors operating. Maybe you can't enter, let's say if somebody's selling widgets and other people are selling widgets and they all agree they're going to charge a certain price for the widgets, and I decide to go into the widget making business and charge half of that, and I get threatened. That's an anti-competitive practice. I get threatened, you better not charge half, you're going to make us look bad, and we're not going to allow it. Bad things are going to happen to you. And
somebody just posted a comment, and I put it on the screen. Everything faded into mist. The past was erased. The erasure was forgotten, and the lie became truth. From George Orwell. Can you see it on the screen, Catherine?
Yeah, I see it. Yeah. Right. Even if they're not formal members of the bar, I don't know the statistics on how many are. I was only a member of the American Bar Association for a year or two, and I just didn't want to pay the membership fees. and I wasn't required to. Well, I could still practice without that. Yeah, that's true. Ron Armstrong saying in the eyes of the state, marriage is the merging of two corporations, and they take control over that. That's what gives them their so-called authority in family so-called court. But we have provided them with authorization that it's not really authorization, it's not really consent, but they take it as consent when we sign marriage application documents.
Right.
That we're giving the corporate state authority to administer our marital property and including biological property. So that's how they get their foot in the door. Well, you agreed to it. You signed here, you know. You don't need a license to be married. You know, the state of matrimony is under God. It's not under the corporate state. Unless you agree, you're going to make it, you know, under the corporate state.
And there, the
No,
question out there now, you know, Mike, in
saw-
court, in other countries, for instance, like in Portugal, I was just there, and they keep all their names, you know, and there's other countries where they keep the maiden name and the name before that. I was looking at my husband's passport because he's from another country, and I'm like, I didn't even know he had all those names, because here they took all those names out and just left, you know, his dad's name. But on his passport, he has his dad's name, his mother's name, and I think their parents' names. There's like 4 different names on there. Very interesting.
Yeah, there was a very brief period in the history of their domestic relations that there was a maternal preference, but for the most part, historically, there's been a preference for the father to have custody of the children. And then they switched to this so-called best interest of the child standard. But I'm not even getting into how it should be decided. I'm getting into who is doing the deciding.
Right, right.
We don't want these people have no business being deciders. Why are we letting them be deciders? We're the deciders. Chisholm versus Georgia, 1793, U.S. Supreme Court decision admitted that we, the people, are the deciders, not them. So,
So they put armed men with guns at the doors of where they're making these decisions, and you either got in those private corporations they call courts, and you either agree to what they decide about your life, or you're going to have a problem with that armed guard watching the door there.
Well, first of all, you know, you're foolish to walk into their fake tribunals. I mean, those are our public courthouses. I understand that, and we're entitled, but right now they are in enemy hands. So let's be realistic. It's not a safe place to go, and they don't have any authority to engage in the activities they're engaged in over there either. And if, you know, they've invited you to come over there, you know, invite an invitation with a threat, you know, sometimes it's an invitation with a threat, and sometimes there's always some kind of a threat with it. You come, or we're going to, you know, to our corporate business meeting, or we're going to do bad things to you. But, and you have really, I wouldn't say, I would say you have basically a 0 chance that you're going to prevail if you've been summoned in. You're certainly, if you're in their fake tribunal, you're already probably lost. So your only way really, I mean, your chances are not completely zero, maybe they're only like 1 in a million. Depending, I mean, unless, the Black Road Wonder is your brother-in-law or something, there are always other considerations. But you can be assured that the decision is not going to be made on the basis of facts and law. The Black Road Wonder is not going to, it's going to make it pretty clear he doesn't want to spend his time listening to your facts. That's real clear. They make that pretty crystal clear. And, they want somebody to resolve this quickly so they can get about and do other things. They've always got other things they need to do besides hear your dispute. And you don't really want them to hear your dispute anyway, because they're going to have other factors operating, including they have an interest in prolonging the dispute that you have, because every time anything gets filed, it of course makes them money.
Yeah.
So,
Catherine, you also wanted to look at the common law, the maxims of law. Did you want to do that?
yes, yeah, I know we're going over an hour, and but I won't get into them as such. I mean, we might go into them on the merits, but I wanted to just show you, first of all, a maxim of law is supposed to be a fundamental principle. It's like in math, an axiom is a fundamental principle. You can't really prove it. It's just everybody knows it's true. 2 points determine a line. You can't really prove that. It just is.
Mm-hmm.
And then once you start with basic principles, then you can logically reach a certain result. So there are maxims. A lot of the maxims, if not most, come from God, or they come from really much higher authorities. You got them up there. Yeah, that's a pretty good definition in yellow there. Stop. Stop. Okay. It's a fundamental principle. It's kind of basic stuff that could apply across the board to all kinds of stuff, all kinds of fact situations. And that's why a lot of them, these are fundamental truths that often come from the Bible. And if you just scroll ahead just a tiny, tiny bit down, okay, there. Right there. The legal profession has a vested interest in keeping the people ignorant of these principles, protecting the need for their attorney priestcraft, which is, the Bar Association rules. And they define it, the arcane craft of specialists, always striving to create the illusion that their craft is too complex to be understood by the uninitiated.
Right.
So, and that provides, an economic advantage. Whenever you're in business with someone who has greater knowledge, particularly if that knowledge has been manipulated so as to be inaccessible to you, you're going to be at a financial disadvantage. Now, here's some examples. Just look at a few examples. If you scroll down, yeah, more. Yeah, there'll be, all right, law, maxims of law. Okay, further down. Further. Okay, there. There, stop. Yeah. And the ones in yellow are the ones that we commonly see. Courts are established not by written law, by common law. Okay. Survival is the first law of nature. The right of man is to defend himself, survival, self-preservation. And there are many others. No man is bound to arm his opponent. Property is what is proper to man, exclusive of all others in the universe. It's a right. No one has a right to take the property of another without the consent of the owner. Okay, so it's just some basic stuff, 10 Commandment type stuff, basic principles. Now, you have the document that is, it was found in a Freedom of Information request. The other document, the one about the so-called maxims of the U.S. Supreme Court, so-called court.
If it was in this PDF that you sent, is it in this one?
It's not in this one, no.
Okay.
It's in the one for United States Corporation.
Oh, no, I didn't see that one.
Okay. It's the let's see. No, not that one. Anyway, there's a
Oh, what was it called that you're looking for, Catherine?
it was called Maxims of U.S. Of Law, Supreme Court Maxims. I think I sent that to you early today.
Oh yeah, I've been going nonstop. I barely
Yeah.
even checked my email.
Yeah, it's that one. Anyway, it was interesting that they considered these to be maxims. They were about their so-called maxims were about hair splitting. Their statutes is all I was trying to get at.
Yeah.
So there were no fundamental principles. I looked through all of it. There were none. And it's a PDF I attached to an email earlier today. Okay, well, anyway, I thought this would go more smoothly than it did, but there's just a lot of moving parts. I was going to bring it back down to why is this important for us today? And that is just to have the knowledge, just to demystify, what they've tried to.
Right. There, I did find one that it's a 299 page PDF.
Yeah. That we don't have to go through all 299 pages to get the flavor of it.
Oh, okay. Do you want to see that one? Hold on.
That's okay. That's okay. Yeah, if you want to put it up, I mean, it'll give you the flavor of what they consider a maxim to be. I mean, we're not even on the same page with them.
Right.
When we talk about maxims.
Right.
And then they got a good cover letter, and it took, I don't know, 5 or 6 bar members to compile the list of their so-called maxims.
Is this the one on the screen, Catherine?
Yeah, that's it.
Yeah.
Okay, so scroll down. Yeah, oh yeah, the first page is kind of telling. Yeah, came from the Department of Justice. Yeah. See, oh wait, stop. Back up a little bit. Back up. So he understands, and the request was for legal maxims that are established principles or propositions. So he knows what they are, whoever is responding to this from DOJ. And then see what they come up with. You scroll down, just pretty much at random.
Mhm.
You get into what they come up with.
Useful quotations from all opinions of the United States Supreme Court from 1933 through 1998 terms.
Is there rules about how to read a statute? You thought you knew how to read before. No, not the way they want it done.
Statutory language.
There are all different ways you can read a statute, with the plain meaning, the ordinary meaning, the historical context,
plain meaning versus ordinary meaning.
Yeah.
Interesting.
Yeah, they're different.
Versus
See what I mean
statutory.
by hair splitting? If Congress uses a term that has accumulated some other meaning than the common law, the court must infer, unless the statute otherwise dictates, that Congress means to incorporate the established meaning of these terms. What?
Wow. What and wow.
Yeah, it's like, what did they mean when they said that? I've seen opinions turn on, what about that comma there? What did that mean? What did they mean when they enacted that?
Right. Yeah, I've heard that too. But there was a comma there. So
Right.
wow.
Right. In fact, this happened in the so-called Common Pleas Court. This was like, I don't know, 40 years ago, in the so-called Common Pleas Court of Wood County, Ohio, in Bowling Green. And I was trying to file something, and I couldn't believe it. The clerk got out a and this wasn't even, the civil rules. This was their local rules. She got out a tape measure, and she measured the distance from the top paragraph of the style to the edge of the document. And instead of, it was supposed to be a half an inch.
Oh, God.
And it was 3/8 of an inch.
These people are just disgusting.
She didn't accept the document for filing.
Wow.
Well, you'll have to ask the judge about that.
Wow.
So I did, and to his credit, the so-called judge did allow me to file the document. And I guess they had there's a reason for every rule. It was to allow enough room for them to put their file stamp or something without covering up anything. I don't know.
Catherine, I'm having trouble with this one on the screen. Maybe you can explain this one to me. Where Congress borrows terms of art in which are accumulated the legal tradition and meaning of centuries of practice, it presumably knows and adopts the cluster of ideas that were attached to each borrowed word in the body of learning from which it was taken.
And the meaning will convey to the judicial mind, unless otherwise instructed.
To the judicial mind, unless otherwise instructed. I have no words.
Yeah, that's a basic fundamental principle, right?
Wow.
Yeah. I mean, it keeps getting worse.
Yeah.
And yeah. And these are just how you read a statute, because, and people are supposed to read statutes with this stuff in mind. Because after all, they tell you ignorance of the law, which this isn't law, obviously, is no excuse. So if you don't understand all this stuff, and there's no real understanding of it, because for every rule there's another rule that conflicts, then you're gonna be punished.
How about statutory language must be read in context, and a phrase gathers meaning from the words around it.
Yeah. Well, I think that refers to, for example, how they define a person or a national, and they list a bunch of. This is the example. They define a tree includes oaks and elms. If they say that, is a pine tree a tree? No, because you're supposed to know that includes means you have to interpret this according to the words around it. And includes means this and nothing else. And if you mean to include the possibility of other things being included in the class, then you have to say includes without limitation. So, yeah.
How about interpreting congressional silence?
Yeah.
Because sometimes silence is not pregnant.
Yeah. In other words, it doesn't mean anything.
Silence is not pregnant, but they're saying now that men can be. So
yeah,
gotta watch the wordage there, Catherine. Gotta watch the wordage.
Right. But interestingly, if you scroll back up, that's almost a concession that normally silence is pregnant. In other words, it does mean something. It does imply something. So, because with our 3 notices, they're always trying to say, well, the fact we're silent, that doesn't mean anything. That doesn't mean we admitted anything. Well, it means something. According to this, it means something most of the time. Mm-hmm. And that's why we also put in, if you're silent, you might be deemed to have consented. And if you engage in the following conduct, and we specify the conduct, then you're also consenting. They don't do that for us. And the Chevron defense, that's a basic, fundamental truth that endures over time, right? The Chevron deference, excuse me.
What is that, Catherine?
I have not heard of this before. It's I don't know. When did that come about? It sounds like it sounds like some agency proceeding got appealed to a so-called court, and they're interpreting the agency rules. And I never really got into practicing with administrative agencies. That was just too corporate for me. I always felt that the corporate stuff was just too nauseating.
Right.
Okay. I think there might have been one other thing that I wanted to cover.
Mm-hmm.
That, well, I didn't quite finish on their Sherman and Clayton Antitrust Acts. If they're maintaining a monopoly, and they are, then that is Section 2 of the Clayton Act provides that those who've acted as persons, in other words, bar members, and this is a quote from the statute, shall be deemed guilty of a felony on account of participating in or attempting to participate in monopolistic practices. So every bar member is engaged in a monopolistic practice. What can I tell you? So they're all engaged in felonies. They're all unregistered foreign agents. They're all prohibited from operating in positions of public trust by the Titles of Nobility Amendment. And they think that they're basically Lord God Almighty in the public courtroom. They're not. They're not the legitimate authority, is what I'm trying to tell people in this broadcast. And people are so frightened that
that's the problem. People are so afraid, and they use that against the people. They'll literally yell at you. I mean,
I know. That's why you have to stop going there. You have to go on. The best defense is a vigorous offense, and you have to do what the Messiah told us to do. In any dispute between living people, and every dispute is between living people. Everything else is fictitious. It doesn't exist. They have to create, like Satan does, they have to create lies and fictions in order to operate. We don't have to go along with the lies and the fictions. We're real, they're fake. So we need to do what we do, and that is we operate under real principles that God gave us to live under. And we don't steal from each other. We don't harm each other, and otherwise we're free. And we have authority not only from God, but also even from the enemy. They admit it every chance they get that we're actually the authority. And if we ever gave it away with our signatures on their documents that were given to us in fraud, that does, having a gun to your head is not
right, which is normally the case. Like with everything.
The marriage license application, you're told you'll be considered living in sin if you don't incorporate the corporate state as a bigamous third party to your marriage. And you're gonna, the driver's license and all that. And I'll remind people again that we have the opportunity for several other people to join the multi-claim notice of liability process so that we can get our roads free of the hazards that they create on the roads. And with the goal of having a judgment be issued as a result, as we've issued judgments before. So, and that's something you can take with you and hopefully learn how to use those, not to get yourself further enslaved, but to get the private code enforcers off your back. So, is there any other unanswered question or issue?
Ron was talking about the prenups, and he says that he tells people that prenup agreements are a waste of time because the state was never a party to it, at least if you're going to contract with the state.
Right. And if you're going to enslave yourself to the corporate state, then a prenup is not valid, but they're certainly valid in the world of men and women.
Yeah.
Assuming all other things are equal and that nobody took advantage of anybody else. And
right.
Yeah. But we do this, as far as Ron Armstrong saying, we allowed it. And once we have the knowledge, that can wipe out some of the fear and we can undo it. And I do have a notice process for people who, whether you want to stay married or not stay married, for you to kick the corporate state out of your marriage so that they
Oksana,
don't have any further authority.
Oksana cracks me up. She made
Oh, yeah.
she made this statement when I just saw it now when I was reading that. How can we borrow words of art? Whose art? And how do we borrow? Is there a payment for the borrowing?
Yeah, they're referring to one of their so-called fake maxims of the U.S. Supreme Court, so-called. A word of art is like a technical word. They really mean words of artifice, words of deception. But they don't use the whole word. It means a technical term. You people don't understand the technical terms. It's a word of art. It means something specific to us, big people.
Yeah.
Yeah. It is not. Their statutes and codes are not meant for us to decipher. Yeah, code. They call it code for a reason. They're writing in code.
Wow, I never thought about that, Catherine. You're right. If you think
Yeah.
about that, wow. Yeah, we don't understand demonese. Sorry.
Mm-hmm. Now, well, the expression "ignorance of the law," if that meant anything, it refers to law that everybody can understand. That makes sense. Then the maxim makes sense. But there's so-called maxims that aren't. Nah. So I urge people to get yourself educated, and this is broadcast 25, and there's a lot of basic stuff in episodes 1 and 2, and you can call me. You can go to our court website, www.occr2021.com. You can contact me at wljaradio@aol.com. We need more people not many. We don't need a majority. We can turn this thing around.
We need more, to be honest, we need more people to stand up, to stop fearing man and stop fearing men that are threatening you, and have a little more faith in God and a little more love for yourself, love for your family, love for your friends, love for your neighbors, and stop loving the big black robed wonder guy in a black dress up on a stage telling you what to do, or taking your child, or taking your parents, or taking your home, or throwing you in a cage and saying he has a right to do so. Yeah,
we understand they have a lot of the guns, but let's sweep
sad.
away the big lie that we have a government by consent. Let's just get real. What we're really dealing with is they're purporting to govern us. They have no authority to do it, but they're purporting to by force. It's always been force. They just try and gloss over it. Don't let them lie about it. It's bad enough as it is, but don't let them get away with their lies.
Right.
Okay. All right. Well, thank you all. Thanks, Luciana, for all your tireless efforts, and Keith and Ron and Mike and Angie and both Mikes, and hope to see you all again next time. And please get with me, and we aim to be solution oriented.
Exactly. All right, Catherine, you have a good night, and everyone have a good night, and thank you, everyone, and God bless you all.
God bless you all.